Für die Nachwelt und die Menschen an dem Bildschirm ist das dann schlimm. Okay, nein, bevor Geist sagt, es ist nicht schlimm, dann ist es nicht schlimm. Okay, ja, eigentlich könnte ich das auch auf Deutsch machen, oder? No, maybe there are two people here who don't speak German, so I don't in English. Welcome to this evening in our lecture series on the crisis of democracy, which Normative Orders, our center, is organizing, and which is kindly appreciated, supported by the Stiftung Commerzbank. And it's my great pleasure to introduce a dear old friend and one of the most important voices in current political theory. Hi guys. Hey, Professor David Owen from Southampton tonight. Many of you know him because he's been a visiting professor. Well, but that's a while ago. A visiting professor and a visiting fellow at Normative Orders for in previous times. He's professor of social and political philosophy in Southampton, which Charlotte earlier, where he actually has taught for the past 30 years, much to the delight of that university, and he has been visiting professorships in quite a few places apart from Frankfurt, and quite recently at the Institute for Advanced Study in Princeton. About the areas in which he works, he's quite unusual. He's quite unusual for how broad his expertise is, and also that his expertise in whatever topic he zeroes in is of a very high international reputation. Many of you know his work on Nietzsche and Foucault, and also the debates around the time in the 90s, 2000s, the debates between Habermas and Foucault, and some of David's publications were focusing on the most important points of these debates. He's actually the author of 3 books on Nietzsche. There is Maturity and Modernity, Nietzsche, Weber, Foucault, and the Ambivalence of Reason, which I think was based on your dissertation, right? In Durham. There's Nietzsche, Politics and Modernity, a critique of liberal reason, and Nietzsche's genealogy of morality. His Nietzsche is a fascinating Nietzsche because, as David shows, Nietzsche's philosophy is not inimical, antithetical to democratic forms of organizing collective life. Another area in which he works is the theory of democracy, and that means a democracy not just in a national framework but also in a transnational framework. And there are a number of publications connected to that. Quite a few of them deal with issues of multiculturalism and pluralism within societies. There are 2 hugely important volumes he co-edited. One is Multiculturalism and Political Theory, and the other is Democratic Multiplicity, which he edited together with Jim Tully. Another area where he has special expertise is the normative questions as well as institutional questions of citizenship, and especially migration, which will also be an issue of tonight's talk. And I mentioned a few books in that connection. Prospects of Citizenship from 2011, together with Jerry Stoker. The highly important publication of What Do We Owe to Refugees from 2020, recommended to all who want to think through the complicated issues of migration, and more recently, together with the 2 co-authors, Displacement, Human Rights, and Sexual and Reproductive health. There's also a more recent collection with Jamie Draper on the political philosophy of internal displacement. Among the many honors that have been rightly bestowed on David, let me just mention that he's a fellow of the Academy of Social Sciences and a fellow of the British Academy. David, it's a great pleasure and honor to have you with us tonight. And the talk is, as you see, Civil Geopolitics and the Dilemmas of the Democratic State.
Right. Thanks very much, Rainer, and thanks to everybody involved in the lecture series for inviting me to talk here. It's always a pleasure to return to what I kind of think of as my spiritual home. So, tonight's talk, you might be slightly surprised to know from someone who thinks of themselves as a philosopher, is going to have quite a lot of empirical content. And we're only really going to get to philosophical questions towards the end. There will be graphs. Okay. So, you can look forward to that. So let me start by introducing this term you probably won't have come across before, civil geopolitics. This refers to competition between states over people in pursuit of state goals, conducted by attracting, fostering and forging civil connections to some, and by deterring, disallowing and disavowing civil connections to others. This is not a new feature of global politics. It was, for example, integral to the political restrictions on the emigration of skilled workers in the 17th and 18th century, as well as attempts to attract skilled workers from other polities. It also played an important role in states' design and development of nationality laws. However, from a geopolitical perspective, it was decidedly secondary to competition between states over territory, at least until the second half of the 20th century. This is no longer the case. Rather, regimes and policies of citizenship and civil statuses have now become integral to the global scope of states' ability to embrace, bind and tap individuals and groups as part of its geopolitical project. So in this paper, what I want to initially focus on is the formation of a certain picture of the democratic state and of democratic citizenship, which still shapes both popular and much academic discourse, before demonstrating how a fundamental change in states' attitudes to and relations with those who leave has reshaped norms of peoplehood, membership and demos characteristic of the democratic state. I'll then turn to 4 illustrative cases of novel political strategies that are enabled by this transformation, before finally turning to the implications of these developments for the democratic state and the problems that it poses for democracy. So the emergence of the democratic state is often pictured in relation to the American and French revolutions, that are sometimes seen as founding expressions of the political discourse of modernity. Alongside the rather incomplete and truncated norms of democratic citizenship that these revolutions manifest, however, are 2 further features that structure the form of membership of the democratic state. The first is the jurisdictional principle of territoriality. While the shift from personalist to territorial jurisdiction had been emerging with the political form of the state and its gradual triumph over its immediate competitors, the American and French revolutions linked this jurisdictional principle to the Republican Constitution and make it basic to the operation of law, in particular criminal law. So, only with the French Revolution did territoriality become firmly established as the basic and initially almost exclusive principle of jurisdiction in France. And in a revolutionary decree of 1792, it was even ordered that all foreigners imprisoned for crimes committed outside of France be released. With regard to America, the revolution inherited the emphasis on the principle of territoriality characteristic of the common law tradition, appealed to this principle in its justification of the revolution, and wrote it into the Constitution. So this embrace of the principle of territoriality, should be noted, marks a decisive difference with the classical Roman Republic, which had a personalist system of jurisdiction. The second feature is the emergence of the figure of the nation or people from the principle of popular sovereignty, and the consequent sharpening of the question of who belongs to the nation and who is alien. Just as the jurisdictional principle of territoriality transforms frontiers into borders, so the republican principle of popular sovereignty introduces a stark separation of the citizen and the alien. And here we find a key difference between the two revolutions, namely that the French oscillated between different answers to the question of belonging before eventually settling around a core principle of jus sanguinis, while the American Revolution embraced a radical constitutional commitment to jus soli. In both cases, the primary principle was supplemented by that of jus domicile, a common acknowledgement that residence within the territory of the state does, under the, as it were, reciprocal entanglement of territoriality and popular sovereignty, ground a claim to membership. The consequences of these revolutionary shifts play out across the processes of state democratization and the rise of nationalism in the 19th and 20th centuries. And this brings us to the second transformation, which arises at the juncture of the state's embrace of nationality laws and the effects of their embrace of distinct kinds of nationality laws. Put in its simplest form, the issue that arises is that the differentiation in types of nationality law gives rise to the possibility that some will find themselves with two or more nationalities and some without nationality at all. In the 19th century, it was the former, the issue of dual nationality, rather than the latter, which was the central concern of states for both theoretical and practical reasons tied to the issue of dual allegiance, particularly when you have mass conscription armies. Unsurprisingly, given the mass emigration flows from Europe to the United States of America, this was a particular concern to the American government. And from 1878 until 1937, the USA engaged in 25 Bancroft treaties, named after the diplomat George Bancroft, encompassing 34 other states that governed the conditions under which they recognized the right of each state's members to become naturalized citizens of the USA, and specified the conditions under which naturalized persons were legally presumed to have abandoned their new citizenship and resumed their old one. This clause was needed because roughly 1/3 of those who emigrated to the USA chose to return to Europe. Okay. So these treaties played a central role in establishing both the right of persons to change their nationality and the norm of single nationality, something that was, as it were, then encoded further in the 1930 Hague Convention on certain questions concerning the conflict of nationality laws. And the focus on elimination and managing of both dual nationality and statelessness continued into the post-Second World War period with the 54 and 61 conventions on statelessness, as well as, for example, the European Union's 1963 Convention on the reduction of cases of multiple nationality. The final step in the development of the hegemonic picture of democratic citizenship is the post-World War II process of formal decolonization that marks the near-global spread of the political form of the territorial nation-state. This last transformation entrenches the Janus phase Grundnorm of state sovereignty non-intervention, in which the rights of states to determine their own membership rules and migration regimes are grounded. But it also supports a view of national political society as territorially bounded. We thus find ourselves with a picture of democratic citizenship shaped by the norms of belonging to a single territorially bounded nation, whose sovereignty finds expression through a constitutional state in which it is normatively presupposed that, excepting diplomats and members of the armed forces, only temporary migrants will retain citizenship of the state of emigration, and only temporary immigrants will not take up citizenship of the state of immigration and surrender citizenship of their prior state. Now, whatever its past merits, this picture is no longer a good guide to thinking about democratic citizenship or the democratic state in the world we live in now. To see why, we need to grasp a fundamental transformation enabled by developments in communication and travel technologies in the relationship of the state to those who leave it. A transformational shift in the state's framing of the figure of the emigrant. As Alan Gamlin puts it, in many countries, emigrants and their descendants in the diaspora were long scorned as victims, deserters, or traitors. But in the past few decades, emigrant diasporas have been suddenly recast as heroes, celebrated in glittering national award ceremonies, honoured with national holidays, granted special citizenship-like status, and courted for their remittances, investments, skills, connections, and routes tourism. Put in less dramatic terms, we may say that whereas the presumption of the 19th and most of the 20th century was that the emigrant was lost to the national community, this presumption broke down under conditions in which continuous social interaction with the national community no longer required physical presence within the borders of the state. And this enabled an agenda of modern diaspora governance where expatriates are viewed as part of the national community and as continuing to contribute to the political and economic power of their state of origin. Now, this shift is made manifest in three related transformations: the rise of state diaspora engagement institutions, increasing tolerance of emigrant dual nationality, and the expansion of extraterritorial voting rights. We can briefly review each three of these. So, state diaspora institutions. Okay, in 1980, 15 states had such offices. In 1990, that had only risen to 22. By 2000, it was 40. By 2015, it was 118 states. This is the overall picture. So you can see the sharp increase that arises this century. So things basically kick off in the late 80s, early 90s, and then this century they take off. Okay. This is, if you like, a proxy for the transnationalization of the nation. The nation is now seen as something with potentially global scope. Second transformation is that of dual nationality. Now, dual nationality, obviously, is not a status that any state can unilaterally bring about, since it depends on the relationship between rules in state A and state B. So it involves a dyadic approach to addressing development of dual nationality. But what's of interest to us is the relationship between the decision by origin states to allow their emigrants to acquire a new nationality without relinquishing their existing one, compared to the decision between destination states to all immigrants to acquire its nationality without relinquishing their origin state nationality. So here is the global spread over time. Basically, light blue means only citizens naturalizing abroad. Darker blue means only foreigners naturalizing in the country. Dark green means both. So what we see here again is a significant set of developments. So in 1960, there were only 6 out of the then 87 states in the world for whom dual nationality was, and that was mainly related to the breakdown of empire. Breakdown of empire often sees temporary dual nationality. By 2022, 91 out of 100 96 states allowed dual nationality for emigrants and for immigrants. Okay. What's interesting here, and which I can show you the next graph, is the difference between tolerating dual nationality for emigrants versus tolerating dual nationality for immigrants. So as you will see, both the rate of increase and the absolute number is much higher for allowing one's emigrants to take up a new nationality without relinquishing their existing one than it is for immigrants coming in, being able to take up the nationality of the state without relinquishing their origin state nationality. The logic of both is upwards. The emigrant dual nationality toleration is a much stronger trend and is really basically the trend that's been driving this, because it's largely reciprocity which is driving the immigrant dual nationality. Okay, so if we just nip back, you will see, as it were, that the temporality is fairly similar to that with regard to diaspora organizations. It's this century that you see the radical acceleration of moves. The third element is emigrant voting rights. These can take a variety of forms, and here I'm just going to focus on the most obvious case, which is extraterritorial voting rights. This is the picture. Okay, so in 1970, only 9 states allowed extraterritorial voting rights. By 2023, it was 141, which is almost all the democracies in the world. Okay, so what we've seen here is first a transnationalization of the nation through diaspora organizations. Second, a transnationalization of citizenship. And finally, a transnationalization of the demos. Okay. So the first kind of issue I want to turn to then is, well, what kind of novel political strategies by states are enabled by these transformations? If we take these transformations as a default feature of the world that we have, and they are very unlikely to be reversed, what does that enable states to do in terms of civil geopolitics that they couldn't do before? And I'm going to give you 4, forget that one, give you 4 examples. So the first example is denationalization, stripping people's citizenship. The second is golden passports and visas. The third is passportization of politics and conflict. And the fourth is citizenship as reparations. So let's move to these. So the return of denationalization sets up 2 puzzles. Right? First, given that prior to the mid-19th century, particularly the 20th century, the expulsion of individual offenders like citizens and settled residents from states or even empire as a punishment was in a variety of different forms in everyday use across Europe. Okay? So first question is, why did it disappear? All right. Second question is, why and why now has it returned? So the short answer to the first question is that while banishment proved compatible with a range of ways of conceptualizing citizenship and societal purposes across ancient, medieval, and early modern worlds, the rise of the territorial state, and in particular nationalized conceptions of membership in the 19th century, undermined this punishment both normatively and practically. So as Matthew Gibney has noted perceptively, while nationalism and popular sovereignty led states and citizens into a tighter embrace, they also multiplied the reasons why states might want to spurn foreigners, particularly those judged dangerous or burdensome. Even this desire to discard the foreigner served to further entrench the protection of the citizen from banishment. For the state's right to expel, deport, aliens practically required a correlative duty on the part of other states to accept their own nationals back. So why then has the expulsion of citizens, denationalization, returned? So there are two different aspects that need to be highlighted here. The first is that whereas banishment was a form of civic death, in principle at least, the practice of denationalization is not. Because insofar as the constraints established by the Statelessness Conventions obtained, it can only be applied to citizens who possess or presumptively have legal access to the nationality of another state. So this both enables and limits the exercise of the state's denationalization power. So the transnationalization of the state is, if you like, the effective condition of possibility for the re-emergence of this state power. The second is that while the argument for denationalization is typically expressed in terms of security, this argument makes little sense, not least because the policy encourages a competitive process of racing to denationalize first and cultivates non-cooperation and anti-comity between states of nationality or potential nationality. Voltaire's objection to banishment as equivalent to throwing into our neighbour's field the stones that incommode us in our own remains apposite. Rather, the return of denationalisation can be seen both as a form of symbolic politics. To denationalise is to declare a commitment to the view that some values and forms of conduct are anathema to the state, and as a strategic reinterpretation of citizenship. Notice that this view is entirely compatible with the fact that denationalisation's revival has been both widespread and modest. Many countries have introduced new laws, but have tended to use those powers sparingly. In Britain, pioneer as we are in this area, the country with the most wide-ranging citizen-stripping powers, only 5 to 6 people have lost their citizenship annually in the last decade. So how is this denationalisation justified? There are 3 historical justifications. The citizen in question was never truly a lawful citizen. They owed true allegiance elsewhere, or they were an active enemy doing the bidding of some foreign power. In terms of contemporary denationalisation practices, the implication is that the exercise of this power exhibits that citizenship is to be seen, at least for some, as a privilege rather than a right. And here it matters how this power is entwined with hierarchies of national belonging. Taking the UK as an example, for example, we might note that denationalisation is effectively reserved for naturalised citizens from Muslim-majority countries. It seems that the imaginative leap required to justify turning a citizen into an alien still requires that the individual in question be part of a group already viewed as less than full citizens. In both its past and present incarnations, denationalisation has not simply made foreigners, it served as a tracer for groups whose citizenship notwithstanding are viewed as foreign. So the transnationalisation of membership is here bound up with the hierarchical construction of the nation or people. My second example is on golden passports and visas. This is symptomatic of a much broader trend in which capital penetrates access to membership. We can note that close to 1/3 of the world's countries offer some form of investment migration legislation, and that programs of residency by investment and citizenship by investment made little sense outside the interaction of the transnationalisation of the state with what Antje Ellerman calls human capital citizenship. In various ways, capital and market-based logics have become central to managed migration policy frameworks, such that access to the right to move transnationally and the conditions of admission are increasingly tied to issues of capital, either human capital or monetary capital. For example, Eilish Shahar, in a series of articles, has drawn attention to the ways in which the privileging of various forms of human capital, the race for talent, has led to the restructuring of immigration regimes. So she comments, in today's stratified international mobility market, the focus is not on closing the gates of admission, but on opening them selectively. Increasingly here, the idea of earning membership takes on the dual meaning of proving one's deservingness and demonstrating one's economic self-sufficiency. So the significance of golden passports and visas is that they represent the purest manifestation of a transactional market-based logic of citizenship, in which hierarchies in migration, immigration rights, and conditions of access to membership are given expression in terms of capital. Now, it might be objected that the possibility of such investment policies doesn't depend on the transnationalization of the state. Formally, that's true, but practically it's misleading, and importantly underestimates the transactional outlook with which such investment policies operate. Their attractiveness to investors is tied to factors such as the tolerance of dual nationality and the expansion of rights for wealthy permanent residents, as well as being sweetened by the non-application of admission and membership tests required of other eligible applicants. And they're not simply, as it were, accomplished through investment, they are also framed as an investment in mobility and security. So the specialist legal firm in this area, Henley and Partners, describes themselves as the world's leading experts in residence and citizenship planning and offer clients access to an interactive platform that enables investors to explore the ultimate combination of alternative residence and citizenships to unlock global access, mitigate risk, and create opportunity. Acquiring citizenships and residence follows the general logic of building an investment portfolio. This introduction of what we might call jus capitalia highlights in its radicality the broader processes in which capital has penetrated the civic realm, and as Eilish comments, it's far more just than a change in form. It touches the very meaning of citizenship in a way that may impact the substantive content and expressive value of the good being transacted. Okay, third example. Weaponizing citizenship through passportization. Just two quick examples here. The first is Viktor Orban's granting of Hungarian citizenship to ethnic Hungarians in neighboring states in 2010, such as, for example, the national minority in Romania, by invoking territories lost under the Treaty of Trianon in 1920 in the name of a Greater Hungary. This was followed in 2011 by the granting of extraterritorial voting rights to these Hungarian nationals abroad. Okay. In the 2022 election, Fidesz received 94% of all votes cast extraterritorially. Second example is Russia's use of passportization under Putin. So under the 1992 citizenship law, Russia operated an open-door citizenship policy towards former Soviet citizens, whereby those living outside Russia could acquire Russian citizenship through a simple declaration. They were just required to register initially within 3 years, and then it was extended. And this policy of tolerating dual nationality at the end of empire is not unusual. Okay? Moreover, given the legacy of Soviet Russification policy, had left significant Russian-speaking minorities in most of the post-Soviet states outside Russia, some of whom were exposed to significant levels of discrimination, including, for example, the denial of automatic citizenship in Latvia and the requirement to go through a testing naturalization process. This open citizenship policy was not unreasonable. However, the mobilization of passportation as an irredentist strategy, which first became really apparent in the 2008 conflict with Georgia only came in after the citizenship law in Russia had changed. The 2002 law tightened up citizenship, so old Russian ethnic minorities were now to be treated the same as all other foreigners. Okay, and it's only in 2004, and then coming into prominence in 2008, that we find passportization as a deliberate policy of the state being used. So, August 8, 2008, Georgia launched a military operation against the separatist region of South Ossetia. Russia began a military campaign against Georgia. Eventually, Russian troops crossed the administrative boundaries of South Ossetia and entered deeper into Georgian territory. One of the justifications used by the Russian government for its actions against Georgia was that the majority of the residents of South Ossetia were Russian citizens. Okay, so the Russian president at the time, since Putin was taking a small break as being prime minister, Medvedev, declared the majority of them, the victim of Georgia's attack on South Ossetia, are citizens of the Russian Federation. As president of the Russian Federation, it is my duty to protect the lives and dignity of Russian citizens wherever they may be. What surprised the international community was that more than 90% of the residents of South Ossetia had obtained Russian citizenship before the 2008 war. I mean, about 50% of them had acquired Russian citizenship prior to the citizenship law changing in 2002. But then from May 2004, the percentage went up from roughly 56% to 98% over 5 months. Very successful. So this was accomplished through a massive amount of administrative support provided by the Russian state to enable the inhabitants of South Ossetia to claim Russian citizenship. So the use of passportization, and in more recent cases like Donbass, coerced passportization, does involve a kind of backhanded complement to international law, in which intervention to protect Russian citizens becomes the justification for military action. And it's perhaps unsurprising in this context that some states, threatened by potential irredentist politics by neighbours, have bucked the trend towards the global acceptance of dual nationality, Slovenia and Lithuania, for example, or adopted conditional country-specific tolerance of dual nationality, Latvia in 2013, Ukraine in 2025. Okay, my final example is citizenship as reparations. So we've been looking at the sort of darker side of things. Now let's the reparations. So on the 19th of September 2019, the Austrian Parliament adopted unanimously an amendment to Austria's citizenship laws. It offered direct descendants of the victims of Nazi persecution Austrian citizenship without the harsh naturalization requirements that Austria imposes on immigrants. Beneficiaries can become Austrian without taking up residence, renouncing their previous citizenship, or passing the income, language, civic knowledge, or criminal record tests. This new law, in one way, corrected a blatant flaw in the previously existing regulation that permitted those who fled or were expelled during Nazi rule to have their citizenship restored, but only under the condition that they'd not voluntarily acquired another citizenship. Since most could not retrieve their Austrian citizenship under this law, their children also did not become citizens under Austria's jus sanguinis rule. But what was because they were that transmission was interrupted when the parents decided to nationalize in their new host state country and automatically lost their Austrian citizenship. Only in 2001 did Austria's constitutional court state the obvious: the victims of Nazi terror did not voluntarily renounce their Austrian citizenship, but were forced to adopt a new membership in order to avoid becoming stateless or being considered enemy aliens as citizens of the Third Reich. Now, the Austrian law was a remarkable success. Even the far right, FPO, whose party history and current rhetoric is stained by Nazi affinities, voted in favour. And the uptake of the offer by children and grandchildren of those who'd fled Austria between 1938 and 1949 has been phenomenal. In 2020, 2021 and 2023, the previously small numbers of extraterritorial acquisitions of Austrian citizenship accumulated to 24,200, which is 43% of all citizenship acquisition in that period. Numbers of potential beneficiaries are still far higher and estimated at 500,000, or more than 5% of the current population. Now, Austria is not alone in introducing such policies. Germany has in relationship to Nazis. Spain adopted a democratic memory law in relationship to those exiled in the Frankfurt dictatorship. Portugal and Spain have both adopted laws offering citizenship to descendants of Sephardic Jews expelled from the Iberian Peninsula towards the end of the 15th century. Okay? And there are important critical questions that can be asked about such policies, not least discrimination. So Spain has not offered citizenship to the descendants of the Muslims and Moriscos expelled shortly after the Jews. And the recent German and Austrian positions basically have a kind of inbuilt indirect discrimination against Roma and Sinti people. But for our current purposes, I only want to draw attention to 2 points. First, the effective operation of these policies is conditional on dual nationality. Second, the reparative logic of such policies represents a transnational reconfiguration of the nation or people, not only as a current community, but as a historical community that's been interrupted by injustice which it now disavows. Okay, so those are my 4 examples of novel geopolitical strategies that states have introduced. What are the implications of all this for how we think about democratic citizenship today? The first and most obvious point is that we inhabit a world characterized by various forms of transnational citizenship, where this term denotes forms of membership relation that cross state borders such that 2 or more states have membership-based obligations to a given individual in a way that also shapes their normative relations to one another. To make this slightly less apt and adapting Rainer Baubach, we can identify the 3 most significant types of transnational citizenship as dual nationality, citizens who are also denizens, who enjoy a partial civic statuses in the state of residence and typically also, if their origin state is a democratic state, extraterritorial voting rights, and citizens, what we might call connectizens, who are citizens of one polity and are linked to membership of another polity by virtue of diasporic relations and are granted a kind of external quasi-citizenship. Those are not the only types of transnational citizenship, they're just the most prominent. So that's the first point. Second point to note is that the trends underwriting the widespread emergence of transnational citizenship and the distribution of its forms can be seen as an abstract level in terms of the disentanglement of an understanding of democracy organized under the norm of territoriality from one organized under the norm of popular sovereignty, and the subordination of the former to the latter. This subordination is demonstrated by the fact that what we may think of as the territorial trend to allow immigrant voting rights is much weaker than the trend to enfranchise non-resident citizens, and that the toleration of immigrant dual nationality lags behind that of emigrants. This is not, or at least not yet, the shift to an understanding of democracy purely in terms of national or popular sovereignty. Both norms still operate, but in a relationship of hierarchical separation rather than one of entangled reciprocity. Finally, we may add a third point, namely that citizenship is increasingly bound up with a logic of corporate market value That is in part a matter of capital, human or monetary, and in part a matter of brand value. We can see the former in golden passports and visas, as well as the broader features of managed migration, and the latter in the use of denationalisation, and at least some uses of citizenship as reparations, where this is basically to be conceived as the state rebranding itself for international consumption. From a normative perspective, the most fundamental implications of these points are threefold. First, the democratic state must now be conceived in relational terms. So I may have a thing here, yeah. In relational terms, in that the membership rules of state A interact with the democratic politics of state B. The old separation between national democracy and international comity no longer applies. Rather, we need to develop an account of relational democratic comity. Second, it raises quite sharply the question of political equality and its conceptualization. Political equality within states and political equality across states can no longer be separated out from one another. Focusing on equalizing the positions of residents of the democratic state against existing status hierarchies generates status hierarchies in international political society. Focusing on equalizing status hierarchies in international political society generates status hierarchies within the democratic state. So this requires an account of transnational political equality, a task that becomes even more challenging when we move beyond status hierarchy to encompass power hierarchies as well. And third, we need to ask how these developments impact on the meaning of citizenship. If it's no longer to be conceived simply as equal membership of one self-ruling state in a world of such states. Against this background, it's perhaps unsurprising that contemporary politics across right and left is in important ways a politics of citizenship, of who belongs and of what citizenship is today. And we might suggest, or I'm going to suggest, that there are four main ideal types. So a sovereign politics of the national people. Okay, so a politics that's geared around popular sovereignty conceived in nationalist terms. So you include everybody who is part of the nation. Everybody has voting rights as part of the demos. You exclude others. Second, a sovereign politics of the territorial people. This is the position most favoured by many political theorists. The idea that those who are subject to the law, should, who are collectively bound by the law, should have a say in what the law is. So here the idea would be that you would not enfranchise non-resident citizens, and you would enfranchise immigrants. So probably, the closest to that we have is New Zealand, okay? So New Zealand, all immigrants get full national voting rights after a year of residence, okay? This is an outlier position. Immigrant New Zealand citizens do have expatriate voting rights, but only for a 3-year period. After that, they actually have to go back to New Zealand if they want to renew those positions. So that's the second view. Third view is like a cosmopolitan politics of transactional citizenship. If you like, a kind of libertarian cosmopolitan position where, what matters is that citizenship is a commodity like any other commodity that we can exchange and sell, buy multiple ones of if we are rich enough.